If you're a real estate investor, protecting your assets is critical. One wrong move could expose you to massive liability or an unexpected hefty tax bill. Today, I'm breaking down a common mistake that could cost you thousands: transferring a property from your name into an LLC the wrong way. You'll learn how to secure your investments, avoid unnecessary taxes, and protect your family from greedy lawyers. Trust me, this information you can't afford to miss. This brings me to Ray. Ray asked a question on the Bigger Pockets forum, and I'm going to read it to you verbatim. He said, and I quote, "I've taken the first leap and am closing on a property in Ohio mid-October. We live in Florida. It's my family's first rental property. I have tried to read and research as much as possible along the way, but am discovering that there is a lot I don't know, so I am still learning as I go. Due to more favorable loan terms and a bit of impatience and ignorance on my part, we went the traditional financing route for the property, with my wife and I both being on the loan. I am in the process of putting final touches on an irrevocable trust and Delaware Holding LLC with my attorney. The plan was to open an Ohio LLC that would be owned by the Holding LLC and put the property under that LLC. Holding LLC would be owned by trust. However, I'm reading a lot of mixed reviews on whether I'll be able to put the property in an Ohio LLC. We won't be the primary owners of the LLC, since it will be owned by the Holding LLC. I've also heard lenders may require repayment or refinancing of the loan. Am I basically screwed at this point, or is it still possible to transfer the home to an LLC for asset protection with a quitclaim? Would we be able to put the home in a Holding LLC since our names are directly on it, albeit a Delaware LLC meant to hide our entities? And number two, assuming I can proceed and put the home under an LLC of some sort, what would stop the tenant from just checking the county tax records and finding out who was listed as the last purchaser, and from there come after my family? Would we still be vulnerable at that point, even if the property is in an LLC? Great questions, Ray. Ray has truly taken the leap, and he's about to transform his family's financial future by buying his first rental property. But he is absolutely right to be a little concerned here, and he definitely needs to get these questions answered before he purchases his property. Let's start with Ray's biggest problem: getting this property out of his personal name. As the founder of STR Law Guys, we help thousands of investors protect their rental real estate assets every single day. And Ray has some great questions here that might not only help him, but also help you if you're looking to add to your real estate portfolio. If you're purchasing your first rental property, we have to ask the question, first, what type of financing are you using? Are you using commercial or conventional financing? If you are using a commercial loan, always, I repeat, always close in an LLC. Why? Because number one, you won't have to worry about transferring an asset from your personal name into an LLC after closing. But secondly, you're going to be able to avoid a lot of the negative consequences we are about to discuss that Ray is going to have to deal with. But if you are using a conventional loan, watch out, because there are three possible consequences that you're going to have to deal with before you transfer from your personal name into an LLC. And a lot of this will depend on the state your property is located in. So let's identify these three specific challenges that Ray is definitely going to face. Number one, real estate transfer taxes. In well over 80% of states will charge you a transfer tax for moving your property from your personal name into an LLC. Why? Because states see this as a change of ownership. And technically they're right. You no longer own the property, but you do control the property. The bad part about this is the actual taxes can range on the low end from 0.01% all the way up to 3% in some states. Here, Ray got lucky because Ohio only charges $1 per 1,000 in value for the property. Under this situation, it may not be an undue burden for Ray to pay this transfer tax unless this is a property that's worth millions of dollars. If it is, Ray does have a solution, and I have that solution coming up. The second problem Ray is facing are lender headaches. If you are using a conventional mortgage, there is a clause within your mortgage known as the due on sale clause that you have got to watch out for. If Ray chooses to quitclaim the deed from his personal name into an LLC, he needs to be careful because technically he has breached his mortgage contract. This could allow the lender to call his note due immediately or to raise his interest rate to the now prevailing market rate. This due on sale clause issue applies to every conventional loan because these mortgages have this provision in them, so beware. Because Ray is currently at today's market rate, there's very little chance his lender is going to care if he actually does this right now and moves it into an LLC. But if you happen to be sitting at a sub 4% interest rate right now, watch out. Your lender could come back and haunt you about this if you're not prepared for how to protect yourself. Finally, number 3, refinancing nightmares. You see, if Ray decides to move the property from his personal name into an LLC, and if he just decides to pay that tax, he will not be able to do a cash out or any type of refinance option from that LLC because underwriters will not allow you to refinance a conventional mortgage in an LLC. As a result, he will be required to pull the property out of the LLC, the ownership out, and what's going to happen? He's now going to be taxed. And then when he finishes the refinance and he wants to move it back into his LLC, he'll get taxed again. So in other words, Ray needs to be careful. He could be looking at double taxation. So what is the solution for Ray? It's a solution that very few investors know about. It's known as a land trust. By transferring your property ownership from your personal name into a land trust, and then, I'll show you in a second, assigning your interest in that land trust into an LLC, you will avoid the due on sale clause, which means your lender won't be breathing down your neck. You can also avoid real estate transfer taxes in most states. And then finally, you don't have to worry about the refinancing nightmares we just discussed. But wait, what is a land trust? A land trust is a simple grantor trust that is used exclusively for property. A land trust is a revocable trust, so there is no taxable event when you choose to grant your ownership of the property from your personal name into that land trust. Best part is that by using this strategy, Ray now has a solution to all of his problems. Okay, so what are the steps here? First, Ray would transfer ownership of the property from his personal name into the land trust. This would make him the grantor under the trust. He would also be listed as the beneficiary under the trust. In short, under the Garn-State-Germain Act, a 1982 federal law, this allows Ray to move the property from his personal name into an LLC using a land trust. And by doing this, now in most states, he'll avoid the real estate transfer tax and his lender's not going to be able to try to call that note due. So how does all of this actually work? The magic part of a land trust is what is known as the assignment of beneficial interest. And the best way I know how to show you that is for me to share my screen. So even though this is a different example, visuals help us. And I want you to notice, let's just talk about here. Let's say you have a property in Florida and you have a land trust down here. You would assign your beneficial interest, which would mean you as the grantor can assign your interest into this land trust. So now the land trust holds and owns the property. But here is where things get really exciting. So we've already talked about Ray as the grantor. Ultimately, Ray would end up being the trustee as well. But here is the beneficiary is the one that has all the power under these land trusts. And you can do a special assignment known as an assignment of beneficial interest from Ray's personal name down here in the land trust into a Florida LLC, or in this situation, it would be a Ohio LLC. By doing this, if an attorney wants to sue Ray for something that happens at his property, all of the value of the trust is now held by an Ohio LLC, which means the lawyer's got to sue the LLC. But because the land trust still retains title and the debt, it helps him avoid the real estate transfer tax. It also helps him avoid the due on sale clause, and then he's able to refinance in the future without being double taxed. Ray is also worried about privacy. So even if his property is in an LLC, can his tenants or lawyers still find him in the public records? That's where the holding company comes in that Ray was talking about earlier. Once the property is under the land trust and then held by the LLC, Ray's name will not be on public record. Even if a lawyer checks for prior ownership, a land trust helps add another layer of anonymity, which makes it much more difficult for an attorney to trace it back to Ray. But Ray is also worried that people could look him up on prior tax records to see that he had prior ownership. This is where it's important to remember the difference between privacy and legal privacy. Is it true that many states provide visibility of prior ownership? Yes, that is true. But Ray is forgetting that the moment he transfers ownership into an Ohio LLC that is now held by a Delaware LLC holding company, he no longer owns the asset, so he is no longer the person that should be sued in a potential lawsuit. So even if the greedy lawyers did find Ray's name on previous ownership for the property, there's nothing they could do about it because they would not have legal standing to haul Ray into court because he no longer owns the property. The LLC and the holding company own that property. So now they would have to sue the LLC and the holding company and not Ray. So the best part for Ray is if he watched this video, he now has a solution to his problem. But it's important to remember that might apply for Ray, but every state has its own unique laws and its own barriers and problems to deal with. So you must consult with an attorney like us at STR Law Guys that know each and every state's laws to help make sure you don't make the same mistake. Want to make sure your assets are protected? Look down in the description below and click the link and schedule a free consultation because we help people like Ray safeguard their real estate assets every single day. Now, we just learned about how Ray almost made some very serious mistakes with transferring his property from his personal name into an LLC. You want to learn how to avoid more bad investor advice so that you don't make mistakes that cost you tens of thousands of dollars? Check out this next video where I dive into how you can avoid bad investor advice before you move any of your properties from your name into an LLC. See you over there.